Well, the first stage in the procedure is the disclosure stage, which is basically about getting together information about all of the financial circumstances. Without that information, it's very difficult to know what should happen to the finances on the divorce. So you have to provide open and upfront information about bank accounts, credit cards, values of houses, businesses, land, and so on. So that involves quite a lot of paperwork, and then it is a question of putting that all into a form, a court form called a Form E, which are then exchanged. Each of the clients then has the opportunity of looking at the other person's Form E to see what they're saying about their finances and to ask some questions and raise some further information, ask for further documents if they feel that's necessary in the run-up to the first appointment.
And what happens after the first court appointment?
Well, the first appointment is really about setting a timetable for further evidence to be produced. So, for example, for some of those questions that have been raised to be answered within a period of time, for any additional evidence to be obtained, for example, for an estate agent to value a house or for an accountant to value a business. Then the negotiation stage starts, and that's in the run-up to the next court appointment called the FDR, the Financial Dispute Resolution Hearing. So in the run-up to that hearing, it's all about negotiation. That negotiation might be between the solicitors direct, it might be in a series of meetings involving the clients, it might be in correspondence between the solicitors, but it's about starting the negotiation and trying to work out what solution there could be to the case.
And what happens if you still can't get an agreement after the FDR hearing?
Well, most cases settle either in the run-up to, at, or shortly after the FDR, because that really is a head-banging exercise at which the judge tries to get the parties closer together and if possible, to settle. But if there still hasn't been a settlement, then the case will run through to what's called a final hearing. In the run-up to the final hearing, there'll be updating of information, updating of valuation evidence, and then at the final hearing itself, the judge will hear about all of the information, see all of the information, hear from both of the parties, and actually impose an outcome, make a decision. What should happen to the house, to the business, to the income, to the capital in the marriage, and actually impose that on both of the parties.
And how long might the process take, and how much does it normally cost?
From beginning to end, and depending on which court it is, that process, if it goes all the way through to the end, can take somewhere between 6 and 12 months. There are lots of opportunities to settle along the way, even once you're already in the court process. But if you do have to go into the court process, you should assume it might take between 6 and 12 months. In terms of cost, it depends a bit really on what the issues are in the case. If you have a fairly straightforward case where the assets aren't complicated and the issues are fairly narrow, then the costs can be limited to several £1,000s. If, however, you have complex assets, many issues flying around, disputes about all sorts of assets, the fees can spiral out of control, sometimes out of control in relation to what the asset base actually is. We at Mills & Reeve would always try and give people a very open and upfront and frank assessment of what the costs were likely to be for each of the stages through that financial process and overall. And if possible, we will give people a fixed fee so that they know what their costs are going to be.
So what practical advice would you give to somebody who's just about to go through the court process?
Well, the more of the work that the client can do themselves, the better, because it means that the lawyer has to do less and therefore the fees are less. So one of the main things a client can do is to provide information promptly and in a very organised fashion when they're asked for it by their solicitor. That is likely to involve things like bank statements going back over the last year, tax returns, that sort of financial information that if the client can collate, provide, copy and give to the lawyer, it's there for the lawyer to deal with in a timely fashion and therefore a cost-effective way.